Welcome back to the second part of Law Sessions, Co-Ownership in relation to Severance. Now in the last segment, I introduced you to the joint tenancy. Now though, we will consider the converse or the opposite way of holding property or holding in respect of property in relation to co-owners, and that is of course the tenancy in common. Now in the last segment, we saw that property can be held as joint tenants or tenancy in common, and we saw that joint tenants meant that the persons held as persons holding together. A tenancy in common only requires the unity of possession. Now remember PIT, P-I-T-T, for joint tenancy. In tenancy in common, therefore, all that is required is possession, so all the tenants have a right to possess all of the land. The other three unities do not have to be satisfied and generally are not. So, a tenancy in common or a tenant in common can obtain his interest at a different time from anyone else. He can have a different interest from everyone else. So he can have a larger interest perhaps. So he could have 60% of the property and the other co-owner 40%. A tenant in common does not have to receive his interest in the same way or from the same document. Also, unlike a joint tenancy, each tenant holds an individual share in the land, but it is an undivided individual share. This is important because we are not saying here that each person can take a room for him or herself and say, right, this is my piece of land. Everybody still holds the land in the manner that you're looking at the property as one property. But the person who then has a tenant in common has an undivided individual share. So land is not physically divided up. Each tenant is recognized as having his own share in the land, although it has not yet been divided up. And that is why it is called an undivided share in land. Now, the good thing with a tenant in common, of course, is that a tenant in common can leave his interests in the land in his will to a successor in title. He can pass it under the rules of intestacy. The thing with the tenancy in common is that it operates in English law only in equity. Now, in some jurisdictions, like Jamaica, for example, the tenancy in common can operate at law. So you could effectively have two co-owners buying property in Jamaica where on the title they've purchased as tenants in common. In England and Wales, though, that is not possible, and the simple reason is it would certainly affect property being sold, because can you imagine if you're selling property and have to decide in all the circumstances that everybody has to actually sign off on the sale of the property? Let's assume that one or two or three persons do not want to sell the property and one does. The difficulty, of course, is then it blocks up the conveyancing process. If the legal title requires joint tenancy, then it means that you need all of the joint tenants in order to convey, and you don't have one person, for example, selling off his interests and the others, for example, not being aware, and this of course affects the conveyancing process. So at law, in England, you can only have joint tenancy at law. In equity, though, you can have joint tenancy or tenancy in common. How then do you go from a joint tenancy to a tenancy in common? Well, the first thing is that at law, you can only have a joint tenancy. So the only place you can have a tenancy in common being in equity, then you would seek to sever in equity, and we will discuss what severance is. Now, in short, severance is the act of converting a joint tenancy into a tenancy in common. The joint tenancy may be severed because of the lottery effect or the right of survivorship. The thing is that equity does not like the idea of the hardship created by the lottery effect, because a party may subsequently decide that he wants to hold his own individual interest in the property as a tenancy in common. A party may also want to leave his interest in a will, and so it would be in his interest to be a tenant in common. Now, to convert a joint tenancy into a tenancy in common is an act of severance. And severing his individual interest from the whole is how he goes about it. Now, the effect of severance is to give the severing joint tenant a share equal in size to the share or potential share of each of the other tenants. So, for example, let's say A contributed 80% of a purchase price of a property and B contributed 20%. Now, let's say that they declare themselves to be beneficial joint tenants, and you must watch the examiner on this, because if the examiner says to you that the parties have declared themselves to be beneficial joint tenants, or the examiner says that they are beneficial joint tenants in equity, it means that regardless of any disproportionate contribution, the parties now hold proportionate to the number of persons there are. So going back to our example, if A puts in 80%, B puts in 20%, but the parties have an express declaration as to the beneficial interest, then of course, subsequently to A severing by, for example, a notice in writing, the outcome will be that they will become equitable tenants in common in equal shares. So, to recap then, legal title cannot be severed. And the section for that, of course, is section 36(2) of the Law of Property Act 1925. There is some indication of this, of course, also in section 1 and section 34. If you seek to sever the legal joint tenancy, for example, let's assume you write to the district land registry and say, I want this to be a tenancy in common. All this will do is to convert it into a tenancy in common in equity, as you cannot have a legal tenancy in common. If you have a legal tenancy in common, then people on the title will have their own individual interest, and this of course would make selling the property virtually impossible. How then do you effect severance? Now let's assuming that the parties are joint tenants at law in equal shares, for example. So they've bought and everybody's put in 25% of 100,000 and there's 4 persons. Then what will occur is that each person, if they declare that they are beneficial joint tenants, what will happen then is that each person owns the whole. But on severance, they would get a share proportionate to the number of persons at law. So if there are four persons on the title, A, B, C, and D, let's say A seeks to sever, A would then have a 25% tenancy in common share. Well, the equitable title can be severed, and there are several ways of severance. The first, of course, is section 36(2) of the Law of Property Act 1925, which provides that you can send a notice to all of the other joint tenants. There's also severance by the methods or the ways set out in the case of Williams and Hensman, an 1861 case. And in Williams and Hensman, the court said that one could sever by alienation, meaning a person acting on his own share. Equally, Williams and Hensman provides that you can sever by mutual agreement. Further, Williams and Edmonds provide that you can sever by mutual conduct. And lastly, of course, severance will be effected if one of the joint tenants kill one of the other joint tenants. So homicide will operate to effect severance in circumstances where a joint tenant kills the other joint tenant. Now, those are the ways of severance. And what we need to do, though, is to go through and consider these ways insofar as having an expansion or looking at it from an expanded view. And certainly, the one point that I would raise here as well is you must watch if the examiner, for example, raises circumstances where the co-owners have got individual business interests, or if the co-owners are partners. Because in a commercial context, there are cases which provide that if you are looking at a commercial situation where there's individual business interests, or certainly if you're looking at a partnership, then equity will immediately and automatically find that proportionate to the contributions, there is already a tenancy in common. In the next section, though, we will look at these various ways of severance under their separate heads. And so I will ask you to stay with me after the break to consider the ways that severance may be effected.